In lecture 6, we came to the conclusion that the damage and injunction both will lead the situation into the efficient result. But I also mentioned that it is so under the condition that the negotiation is free of charge, which means the transaction cost of negotiation is zero. So I rewrote it here again. If the transaction cost is zero, both injunction and damage are efficient. Actually, the transaction cost plays a great role. If it is zero, anything's possible. If there's a itty bitty small amount of money people can achieve through negotiation, they have no reason not to do it. So they will pursue the efficiency to the extreme. Inefficient means still there are money to be gained by everybody involved. And inefficient means even though there's money to be gained, people don't do that. And if there's a transaction cost is zero, usually people achieve that extreme efficiency through negotiation. They talk to each other, oh, we both can make money, why don't we do that? That is negotiation. The negotiation will never reach a agreement unless the both party would gain. So, in other words, the flip side of it is if there's something both party can gain, then there's no reason not to do it. That is typical economics. If you look at the economics book, they do not talk a lot about the transaction cost at all. Personally, I think the difference between economics and law is in economics, we are dealing with a little bit ideal situation where people can freely talk to each other without fighting. On the other hand, so the transaction cost is usually zero, or they want to assume it's zero. But in reality, where this law legal system applies, people fight each other. The negotiation is never free. So this negotiation kind of make a lot of headaches in the real society. And certainly the economists want to avoid it. So they usually assume that transaction cost is zero. People can negotiate anything. That's why they say, oh, the market system can be only perfect because people will negotiate to get the most out of it. But then once the transaction cost kicks in and people cannot negotiate everything, then everything matters. Under transaction cost zero, whatever stupid legal system the government may have, people will negotiate it out of it and do something. However, if negotiation is not possible, the stupid government rule would lead to stupid result. A smarter government rule would lead into smarter result because the transaction costs prevent people from negotiating, so they do not have the means to circumvent these government rules. Okay, so let's move to the realistic case. If transaction cost is big and transaction cost is small, what is the criterion to be big and small? The big means the negotiation is impossible because the negotiation cost is so big. Okay, so people do things without negotiation. That is the meaning of transaction cost is big. What is transaction cost small? There is positive, strictly positive, above zero transaction cost, but it's not big enough to prevent people from negotiating each other. So negotiation is possible, but with a cost. That is small case. Let's look at the big transaction cost first. Injunction. If it's an injunction, the power plant has to install the scrubber at $400 because this is injunction. The government would say, oh, you should not exhume any of the soot and dirty air out of your chimney. the only way to do it is either shut down the whole factory, which costs you 1,000. Instead, so install the scrubber, then you would not damage anything to the laundry company. So 400. What if it's just that? And then the power plant cannot do anything because it cannot negotiate the laundry factory. What if the damage is the sentence, monetary compensation? Then the power plant pay 200 after causing the harm. Okay? So what would be better? In this case, 200 loss is better than 400 loss. And from the laundry factory side, whether it's injunction or damage, in both cases, their original profit of 300 would be recovered. So laundry company, whether it's injunction damage, doesn't matter, the same profit. And power plant wise, the injunction costs 400, damage 200. So damage is a better verdict here. But then you may say, that's not a fair way to conclude this. The damage is better than injunction. Because the damage is 200, injunction is 400, scrubber is 400. What if the damage is 400 and scrubber 200? Then injunction costs the power plant 200, damage costs 400. It seems right, but let's think more. Number 3, as you have suggested, I will assume the damage is 400 now and the scrubber is 200. So the injunction would be better. But then, if you are the power plant company, what would you do? Are you going to pay the laundry factory 400? Or what can you do? What can you do? You can install the scrubber on your chimney. Can you do that? That it was the damage, not the injunction. Yeah, but the judge says if there's damage, you have to compensate. But as soon as you install the scrubber on top of your chimney, there would be no damage. So you don't have to pay. The judge cannot tell you to pay in the future. So what I mean is, even though the negotiation is not possible, from the power plant point of view, when the order is damaged, he can voluntarily move to injunction. When the judge said, in the future, if you cause any damage to laundry company, you have to pay the money. But if you don't want to pay money, one option you have is install the scrubber on the chimney. Yeah, but the transaction cost is 0. The transaction cost occurs only the power plant talk to the laundry. But then, installing the scrubber on top of your chimney, you don't have to talk to the laundry company. It's your decision, it's your factory. Therefore, the Beijing rule is, once you are ordered to be injunction, you cannot freely move to damage unless you negotiate with your counterpart, the laundry company, which is impossible in this case because big transaction cost. But when the verdict is damage, if you prefer injunction, you can do it by yourself. And there will be no transaction cost occurring because you don't have to negotiate. Okay? So, the general conclusion is, if you look at the first line, if the transaction cost is big, which means negotiation is impossible, damage is sometimes better or sometimes equal to the injunction. If damage is better than injunction, then the power plant will choose damage. If the injunction is better than damage, then the power plant company, without negotiating, without occurring any transaction cost, freely move to injunction and put the scrubber at the chimney. So if the negotiation is not possible, the conclusion is damage is better than injunction. Okay, that is rule number 1 concerning this, how to protect the property right. Now, what if the transaction cost is small? To be honest with you, there is no clear answer. It's a little bit like a case by case. Naturally, that's why we need a judge. I mean, if we can theoretically decide everything once and for all, we don't need any smart guy to be the judge and pay him or her huge money. But case like this, sorry, the transaction cost is small. It's a little bit of case by case. So the judge, smart judge, should look at it carefully. However, there is one factor which prefer the injunction in this case. So when negotiation is possible, the rule of thumb says it's probably more likely the injunction is a better verdict, better way to protect the property right than the damage. Why? If you look at the case where the damage is a verdict, first of all, I said as if it's so clear the dirt and dirty things on the clean shirts and blankets and towels the laundry company produced came from the power plant. But that may not be the case. Okay, it's from faraway country like China. China sent something, burned something, and like jet stream brought into Korea, and it landed there. So the first quarrel dispute would be where this dirty thing came from. If the laundry company cannot prove that it came from the power plant next to it, then there would be no verdict. So first of all, people fight fiercely whether the power plant, the dirty air out of power plant chimney really damaged the laundry company. That itself is a big dispute and takes many experts and takes many hours of lawyers and costly. And let's assume that now the judge said, okay, I'm pretty sure, like above pretty sure, that this dirty thing that damaged the laundry company came from the power plant. Okay. And then says, oh, that is my verdict. Then the laundry company and power plant says, sir, is that all? Because you said it's damage, you have to tell us how much money the power plant should pay the laundry company. That is not an easy matter. I tell you the numbers, but from the judge's point of view, he does not know what scrubber is. He does not know how much damage the dirt caused on the laundry company. If you're a laundry company, the loss is 200. Are you going to say 200? No, they would say 2,000 because they can get more money out of the power plant if they exaggerate. On the other hand, the power plant knows it's 200, but he would say, oh, $20 because he doesn't want to pay. He wants to pay less. So the original number is 200. One party, 2,000, 1,000, they exaggerate. The other party, oh, $10, $20, they just make it small intentionally. So it's a huge task for a judge who never run power plant, who never run laundry factory, but somehow have to decide the monetary amount. But then the both sides brought in many experts and brought in lawyers, and they fight over and over for several years. So this two stage, who's guilty or not, responsible or not. The second stage, if responsible, how much responsible? What is the money amount? This two stage prolong the court procedural a very long time, and that costs you a lot. The lawyer charges you by the time, and it gets 2 years, then it might be true that whatever damage you will get, maybe you pay more to the lawyers. That's all cost. Okay? On the other hand, what if it's an injunction? In injunction, the court just have to make a verdict whether it's responsible or not. Don't do it. So you don't have to go through all the procedure, how much damage really occurred. So at least the injunction procedure is half or less than half of the damage procedure. Okay? So the rule of thumb says, because the court procedure took more than twice if it's a damage, and court procedure itself is a transaction cost, if you can negotiate anyway, then, can it justify all this kind of thing? Of course, in real situation, things can vary. There are a lot of stories on this. So, but the elephant in the room is the damage procedure at the court is maybe twice costlier than the injunction procedure. So if the transaction cost is small and negotiation is possible, maybe the judge should think about injunction before the damage. Okay? This is a little bit different story, but let's have a little bit of not so like calculation related things. Play or cinema. You go to a play. There's a real actor, real actress doing something and you watch it. That's play. What about cinema? You wonder, there's a cinema through over 2 years. It was a summer, boy and girl meet, and winter, they love, and summer again, they fight and separate. Then how long would it take for the cinema to film all this? If you say, more than a year because it's a summer, winter, and summer again. No. The cinema goes, in the summer, they shoot the boys and girls meet. And at the same time, they shoot the boys and girls fight and separate. Wow, what about the winter? In winter, they shoot the winter scene, they love each other. Of course, if you go to the theater, they show you the first meet in summer and the winter, and it's not the next summer, but they shoot it at the same summer, but as if they shoot it the next summer, they show it to you. So the thing is, when you are filming cinema, there is no audience there, so you don't have to worry about this order. But in play, you cannot do that. You cannot put summer, girls, boys meet, they fight, and in winter, then our audience there is confused. What is going on? Something like that. Why am I talking to this? The British and US court system is like play. They do all this timely order. On the other hand, the continental Europe and Korea and Japanese system is more like cinema. I'll explain to you why. Britain and US, there are 12 juries who makes the verdict usually. 12 juries. They are not a legal, they do not have a legal vocation. They are just common people like you and me, and one day you got a call, come to the court and be a jury. And so they are non-expert. They do not know what investigation is. They have no scientific background and things like that. And then when you get there, you would be educated how to make a verdict, and the prosecutor and lawyer compete each other in front of you. So the prosecutor and lawyer in Britain and US should be a very smooth talker, persuasive, and things like that. On the other hand, the continental Europe and Japan and Korea. Why Korea and Japan has continental Europe? The Japan, when it first brought in the Western system, they went all over the world. They went to Britain, and at the time there was British democratic system. They think, oh, we have like a king, emperor, and we are a little bit dictatorial. We don't like that. America same. But then they went to Germany. They found out there's a Kaiser and it was dictatorial, and wow, it's like Japan. So they accepted the German system. That is why at that time the German has an emperor and Japan has an emperor, so they think it's the same thing. And then Korea, as you know, is a colony of Japan, so we follow that system too. So the continental French, Germany, and Japan, Korean system, we do not have a jury basically. We have the judges. The judges are expert. They are smart people, they pass the exam, and they have been in the legal system in their life. And then they don't want to get educated by prosecutor and lawyer. They probably think, oh, I know much more than you, prosecutor and lawyer. So don't talk to me. Give me what you have found. And they look at it, and they never allow the prosecutor lawyer to talk. They just ask, oh, the lawyer, you missed this evidence. Just submit to me. Prosecutor, your argument on this is not strong enough. Submit more, something like that. So the Korean court is more like filming the cinema. On the other hand, the British US court is more like play. Once again, the play is in front of audience. The cinema, no audience, just expert on cinema, they do each other. So the different atmosphere between them. So my question is, which system would be better? The British US or continental and Korea? Well, if you ever had a look at the O.J. Simpson case in 1990s, that was almost like 25 years ago. And, everybody pretty sure who is the killer, but then the juries, they just, I don't know, but they just couldn't find out the killer, even though it's so obvious, and people are furious. I mean, like, oh, who is those dumb juries? I mean, like, if it's any smart judge, they would immediately find out he's a killer, but somehow this not so, smart jury, maybe, they just, somehow misjudged it. And how can we trust this, something like this important to the just common people who doesn't have any scientific knowledge on DNA and things like that? So, obviously, British US system, the juries are not expert, so they may misunderstand something, and they are not like smart enough, like King Solomon smart enough to make a judgment. So it has a limitation. Oh, then what about judge? They are expert, they are smart and everything. One problem with judge, many people think, is they are in their job too long. Think about that. You are a lawyer. You want to bribe the system. The judge, you know him because there are only handful of judges in your city, and you get to know them, and you get a better verdict, which means corruption. Corruption is always a problem when there's a small number of judges who make all the decisions. On the other hand, if it's a jury, 12 jury randomly chosen, how can you bribe them? So, the two systems, we do not know which is better, because on one side, the non-experts may make a wrong decision. On the other side, the small number of judges, some of them might be corrupted, easier to bribe them. Okay, so we're gonna, maybe, who knows, in the future, the AI, artificial intelligence, would be the judge or not. Thank you.